Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics, or are your politics starting to shape your faith? In other words, what do you do when God and government come face to face? I'm your host, Orland Johnson. Let me introduce you to our guest panelists for today. First, we have with us Mr. Todd McFarland, who's the Deputy General Counsel for the General Conference of the Seventh-day Adventist Church. We have Mr. Tim Schultz, who is the president of the First Amendment Partnership. We have Mr. Lawrence Brown, who's the Assistant Director of Public Affairs and Religious Liberty in the Northeastern Conference of the Seventh-day Adventist Church. And we have Dr. Timothy Golden, who's a visiting professor of philosophy at Whitman College. Gentlemen, great having you here with us and looking forward to our conversation today. You know, it's interesting, I couldn't even believe it, that it's actually been 30 years since RFRA has been passed. The support of really a broad coalition was unimaginable today, but somehow it took place 30 years ago. It was basically an American question of politics, religion, and civic alliance that helped to put it in place back in 1993. But the fact of the matter is that this particular broad coalition was diverse. And when you think about politics today, you have to ask yourself the question, is there any way possible we could have seen something like RFRA passed today? But I don't even understand where we would have been without RFRA. It prohibits the government from significantly restricting an individual's free exercise of religion without demonstrating a compelling interest. And it also put a huge benefit on the government to make sure that whatever they were doing, they weren't infringing upon people's rights. You know, Tim Schultz, when you think about this piece of legislation and based on the work that you've been doing, trying to imagine what life would be like without RFRA, or even trying to imagine, is there any possibility we could have passed something like that even today, just seems staggering. You know, tell me a little bit about your work with it and just your general thoughts on that idea.
Well, it's definitely become more controversial, and it had already become controversial by about the year 2000, Orland, because remember, the Supreme Court ruled in the late 90s that RFRA didn't apply to the states. States, if they wanted RFRAs, have to pass their own, and we've been successful in passing a whole lot of those. Over 30 states now have that as their standard. But remember that the Congress came back and tried to repass a RFRA that applied to the states at the end there of the 90s, and they weren't able to do it. They had to settle on something that we now call RLUIPA, which just applies to prisons and land use cases, because the coalition that had passed RFRA almost unanimously just about 8 years before had broken down, and it was impossible to pass, you know, the kind of reinvigorated RFRA by, 5 years after it had passed.
What was fascinating to me is, as you said, Orland, a coalition such as the one that got the original RFRA done in 1993 today is is really unthinkable. I remember after the Smith decision was issued, I remember turning on C-SPAN and I saw Ted Kennedy and Orrin Hatch standing there side by side condemning the Supreme Court decision. I'm trying to imagine a conservative senator and a progressive senator today doing the same thing, and I can't even think of it. Mm-hmm. To me, what is extraordinary about RFRA is that it took something. I mean, for 27 years since the Sherbert decision in 1963, the compelling state interest standard was the law, meaning that if the government was going to infringe on the free exercise of religion, it had to show a compelling interest. And of course, the Smith decision changed all that. And, when you really study this decision and you look at the 1997 case that Tim Schultz just referenced, Bernie versus the city of Bernie versus Flores in 1997, you really get to see how powerful the Supreme Court is. Because what the court said, in the Bernie case was, look, under Section 5 of the 14th Amendment, Congress exceeded its enforcement power because it's our job to interpret the Constitution, not Congress's. So it's really an extraordinary case that shows the extraordinary power of the Supreme Court. But as we're seeing, as Tim referenced a moment ago, we're seeing lots of states now follow suit in ways that Congress couldn't get done to impose on the states. States are now doing themselves. So it's been a fascinating evolution of this decision.
You know, Todd, when I think about even the title, when you think about Religious Freedom Restoration Act of 1993, just hearing those words make me wonder, could we even have something that utilized those words today? Because what would be restoration and what would be religious freedom? All of those topics have changed from a definitional standpoint so much. But could you imagine the work that you've done over the last several years without RFRA? I mean, you know, how important has it been?
Well, RFRA was, I think, was a landmark set of legislation, and I think really sent a notice to the Supreme Court where the country was on religious freedom. While that has, become less of a consensus over time, it has been vitally crucial in sort of advocating for people in the federal government. I think nowadays, the question moving forward is going to be, the case that made that RFRA necessary, was a case called Smith. That case is probably on the chopping block. But, in the interim here, RFRA has been vitally important and will continue to be so. But, it was important, I think, as an interim step to keep a robust First Amendment free exercise clause as part of the national conversation.
You know, Lawrence, when you take a look at this, and in particular, when you look at some of the places in the United States where these issues have been more prevalent than others, a place like New York City seems to be a place where you see a lot of this activity, but it really seemed like they wanted to codify a lot of the decisions that were taking place. But as many of the panelists have just mentioned, it looks like we're still fighting just to even hold on to some of the things that we kind of viewed as being sacrosanct.
Well, here's the thing that I find most troubling. There are no simplistic answers to how we got here, but it really does in many aspects boil down to power. People in their thirst for power and in their push to consolidate power have found out that one of the ways to have power is to get everybody on the same page, no matter what. And so it's no longer a situation where you can have a discussion and come to a consensus on the basis of what's in the long-term best interests of the country. Now it's about, listen, we got to have power. And whether you like it or don't like it, whether you feel this way or don't feel this way, this is what you have to do if we're going to have power. And that's how whole coalitions can coalesce behind people who clearly are not qualified for the roles they're trying to take. Power has allowed people to push every other consideration to the background. And unfortunately, one group seems to have nailed this down a little better than the other group, although the thirst for power has basically intoxicated the entire system. And it is a sad commentary. It is a sad commentary on where we are as a country today, that things that are in everyone's best interest often die on the cutting room floor just because it doesn't fit into the power narrative.
Well, all I can say to what Dr. Brown just said is that human nature is undefeated, right? And I think that we all of us that are panelists today have a common view about what human nature is. And even though the founders of the United States got a good deal of things wrong, but they were wrong about a great many things, they were right about human nature, right? They really were. If you read the Federalist Papers, they really understood human nature. And the system of government that we have in the United States, while deeply imperfect and right, does allow us to check human nature, the dark realities of human nature in a way that other systems of government don't do quite as well, in my opinion. So for all the problems that Dr. Brown just outlined, I think that the real problem is ultimately human nature itself.
No, I was just going to second what Dr. Brown said a moment ago, is that ideology has supplanted a spirit of bipartisanship. No one can do no one can do anything nowadays. And when I think about no one can do anything in a spirit of bipartisanship nowadays. And when I think about the difference between the Congress of 1993 and the Congress of 2024, I can't help but think that social media and the proliferation of all these different communicative technologies have put people in silos, and people really believe that the way they see the world is the way it is. And you only follow people who agree with your worldview. And if your worldview is skewed, you're constantly reinforcing your misunderstanding of the world. So I think that has had a huge impact on how people see the world. And as a result, it's had a huge impact on our politics. And the impact, sadly, has not been a good one, as Dr. Brown pointed out.
Well, I just want to point out, three big developments that happened since RFRA passed in 1993. Okay. And I think if we look back at these things, we can say, wow, something really changed when those things happened, right? The first thing was the Republican takeover of Congress in 1994. It signaled a more pugilistic turn. I'm not saying it was right or wrong. It just signaled a more pugilistic turn in our politics. The second thing that happened that began later that year was the O.J. Simpson trial, right? The O.J. Simpson trial made cable news a much bigger part of our national cultural conversation than it had been ever before, right? And then the thing that sort of really cemented it, the coup de grace was when Roger Ailes left the Republican Party and became head of Fox News. And Fox News really became a kind of infant version of what it has become in 1996. Again, I'm not morally commenting on any of those developments. I'm saying those three things fundamentally changed our politics in about a 3-year span in a way that if you look back on, you can really see it in a way I don't think it was so clear at the time.
And then if you add to that, Tim, what happened on 9/11 and what ensued after that, that is actually being fueled by certain ideologies in charge of media, et cetera, you can start to see, along with the proliferation of technology and the advent of social media, you can almost see, tracing all the things that you mentioned, how we got to where we are today. So I'd agree with that.
And unfortunately, if a good idea doesn't feed the power narrative, then that good idea will not get implemented, even though everybody in the room might agree that it's a good idea.
Well, I guess the last thing, because I know we're short on time, but we saw a turn. State RFRAs were still bipartisan in 2013. By 2014, nationally, they had become highly controversial. Well, what happened in those years? Well, that was sort of around the time that a majority of Americans began to own a smartphone, right, and have social media apps and have our politics mediated through Twitter and Facebook. And again, that made possible a kind of polarization that was much harder to do, prior to, say, 2012, 2013. So all of those things, I think, are factors, and it's just, we are where we are, I'm
going to have to let that be the last word, but, it's amazing that some of these most powerful pieces of legislation are actually starting to feel like relics right now. But as we see the communications change in our world, it just seems like this is what we're going to see even going down the road. There's an interesting piece of legislation that we see that is now starting to be codified as we look at cases. And the case I want to talk about is Holt v. Payne. In 2011, we had an inmate by the name of Gregory Holt, who was in Arkansas in a state prison, and he sued for his right to grow a beard in accordance with his Muslim faith. He was defended and it went to court, and Holt ended up winning his case. But it looks as though a few years later, we're now starting to see some issues where there is some questions and concerns whether or not he should be allowed to wear certain pieces of article that are also part of his faith. And I guess the question I have to ask when we start taking a look at all of these different matters, the idea of protecting individuals' religious beliefs while they're incarcerated seems to be something that makes a lot of sense. But I guess the real question comes is, where do you end up drawing the line? In many of these institutional facilities, how you look or, what your quote unquote clothing is going to look like, the uniform, it's kind of part of the whole protocol and how you maintain law and order in these institutions. I don't know how you juxtapose the ability to be able to continue to do what you need to do from a quote unquote incarceration or rehabilitation standpoint, but then allowing an individual to have full access to their religious beliefs even while in jail. And when you take a look at that, it makes me wonder what's the next step. Todd, when you look at this particular case and you have to ask yourself the question, even if I agree with where I am today, it begs the question of where might I be down the road, and will I agree with where we might be down the road? Or am I missing something here?
No, so this is a reminder to our audience. So, Mr. Holt, this is his second time up through the court system. As you said, the first time dealt with his ability to wear a beard. He lost at both the district court and the Court of Appeals, the Eighth Circuit there in Arkansas, and then it's the Court of Appeals. It went to the U.S. Supreme Court, and he won in that case. And he's now back over having to wear, kafkas and various items on his head, various attire. And he lost the district court, and then the Court of Appeals overturned that. Prisons have a very difficult job. There's no question about that. But it also is not populated by people who respect the First Amendment or respect prisoners' ability. And I think what the court is saying, and what we've often found in this litigation, is you can't just yell security and then just, that overrides every other interest. And I think that that's where we're at, is these prisons. And I don't know that prisoner cases have a whole lot of signaling beyond the corrections context. You have prisoners making claims sometimes that are, fanciful. I remember we had one who had reached out to us for representation in a prior case. They had said they weren't Jewish, but they kept certain Jewish feasts that required them to eat basically what they desired, and what he desired was a steak and a pizza. And that was not a case that we took. But you have other people like Mr. Holt here who are making, legitimate claims. And I think the courts need to hold the Department of Corrections accountable, because the just sort of reactionary no is just built into the system.
So here's my takeaway from cases like these. And yes, when you're talking about prisons, you are talking about a special environment. But even if that is true, there's a larger takeaway here. We all want to have the convenience of being able to come up with bright line rules, stick them on the board, and move on with life. And it doesn't work that way. When it comes to issues of religious liberty, the reality of the situation is we must, whether we like it or not, whether we find it inconvenient or not, whether we find it annoying or not, we must stay engaged with the process, because life is dynamic. It's not static. And so people who want to just be able to say, okay, you can do X, Y, Z and keep it moving, as this case points out, you're now dealing with a situation where you have subgroups developing, and where one Muslim group might have trouble worshiping with another Muslim group because of, built-in differences. These are things, unfortunately, that have to be considered and taken into effect. We will never get to a place where these rights are just a natural part of our DNA and we can trust in human nature to do the right thing. We must stay engaged. And guess what? A victory 5 years ago, 5 years later, it's a what have you done for me lately kind of situation. We will never get to exhale. We will never get to sit back in the shade, drinking lemonade, living like we got it made. Instead, we will always have to ask the tough questions, and we will always have to grapple with the issues if we are going to see the kind of outcomes that make the overall quality of people's lives better. That's a hard reality, and it just is what it is.
Yeah, well, I was just going to say that I think that these prisoner cases actually test us on sort of two ends, right? Because on the one hand, prisoners are unpopular. I mean, Mr. Holt committed crimes. There's no doubt about his guilt. And so it tests your commitment to religious freedom when you say that even a guy like Mr. Holt actually has religious freedom. So in that sense, it's a real test of our commitment to what we say are our ideals. On the other hand, I think the prisoner cases help us in a different way. I mean, it probably won't surprise you to hear this, Orland, but prisoners have been known to make up some creative religious freedom claims. They have a lot of time on their hands, and lots of these prisoner cases do involve creative assertions of the free exercise of religion to be kind. The good thing is that the law only protects sincerely held religious beliefs. right? So a lot of the hypotheticals that you hear against things like RFRA laws, for instance, are based on hypotheticals about religious beliefs that are not sincerely held, that are made up just to get out from under some kind of legal consequences. And so it is worth reminding people that both RFRA and its cousin RLUIPA require the assertion of religious rights to be a sincerely held belief. And I think that sort of ferrets out a lot of wheat and chaff. It sort of separates them in a helpful way.
But Tim Golden, how do you start to find a court or anyone that starts to determine what my sincere belief may be? You know, I've seen a few cases where there were some individuals who were in jail that their religious beliefs was telling them they needed to eat spaghetti and they wanted to be a pirate, they needed to wear a hook, they had to have a patch on their eye. And I don't know if I could say they didn't sincerely believe that. I mean, where do we draw the line here? I got to start doing sacrifices of animals. I really believe that to be the case, but how do we juxtapose these two things?
I think we figure it out on a case-by-case basis. I think that's the way you have to figure these things out. As Dr. Brown said, bright line rules don't work well in American democracy because we care about things like individual freedom. We're different from other countries in that, as Tim Schultz pointed out, you commit a crime, you forfeit all of your civil rights and civil liberties. But we in America have committed ourselves to something very different along those lines. So it will always be a challenge. And sadly, that question that you asked, Orland, will in some sense always be unanswered. The most compelling thing, I believe, about American democracy is that the work of it not only lies with the people, but that the work of it is perpetual. We will always be in a sort of political state of insomnia, never able to rest, never able to say we've arrived, because the moment we say we've arrived, we come up with another case. There'll be another person, another prisoner, another individual who's saying, I have religious freedom here that needs to be attended to. And because we have committed ourselves to the protection of those freedoms, we will have to, again, pay attention to that case. So I wish it were easy. And as we discussed in other segments here before, sometimes rules stay for a long time and then all of a sudden they go away. And then there's more work to be done. So I wish I could say that we'll get to a point where the Mr. Holtz of the world will no longer be banging at the door of democracy seeking entrance to legal protection, but I don't think we could ever say that. We have to roll our sleeves up because we've committed ourselves to a form of democratic politics in this country that means that the work of it is perpetual, and so we're in it for the long haul.
And there's one other elephant in the room. Don't want to offend anybody, and in the interest of full disclosure, I'm an attorney myself, but the fact also remains that it's in the interest of some groups to learn how to game the system on behalf of their clients. And as long as you have attorneys who will always look at whatever set of rules come down and immediately start to ask the question, how do I massage this? How do I work this? How do I twist this? How do I game this? That's always going to be another force or another tension in the system. So for all of those reasons, we just never get to take a day off. We just got to stay alert and make a good faith effort. And I guess that's the underlying thing. Make a good faith effort at getting us to the best possible place, all things considered.
Well, there's one other elephant in the room, and I can't be alone in noticing that when Orland talked about the pirate guy, he did so in a kind of yearning and even aspirational way. And I am not going to judge.
Well, I got to tell you, though, Todd, if you're a warden now And now you've got to try to figure out, how do I manage this prison where I have no idea what all the religious beliefs of everyone may be, whether they're sincere or not? I mean, what kind of position are you in from a leadership standpoint in order to manage a prison, but in the same breath, make sure you're not infringing on anybody's religious beliefs?
It puts wardens and others in a difficult position because, they understand that if religion or something starts to be viewed as a get out of jail free card, no pun intended, or a loophole, that, that is something that the prisoners are going to jump on. I think there does need to be a little bit more seriousness put with this. And in all fairness to the warden, the district court got this wrong as well, right? You had a court of appeals that had to reverse it and say, here's the proper legal standard, go apply it. And so I don't envy what they're going to do, but if you sign up to be a warden, you've got to take people's constitutional rights into consideration. And unfortunately, they don't always get that right.
I'm going to have to let that be the last word, but it seems as though maybe the freedom that you have in prison might even be a little bit better than some of the freedom you may have outside. So we'll just have to see where all of this goes. Tim Schultz, tell me something I don't know.
Bad news, RFRA would never pass today. Good news, it's never going to be repealed either, because in the words of the late President Ronald Reagan, a government program is the nearest thing to eternal life that we will see on this earth.
Tim Golden, tell me something I don't know.
The Supreme Court will hold that Donald Trump is not immune from prosecution, but it will not be unanimous. It will be 7-2 with Justices Alito and Thomas dissenting.
Wow, that's real specific. Lawrence Brown, tell me something I don't know.
Well, despite the feeling that where we are in politics today with everyone being so dug in, the reality of the situation is that we got to this point starting a long time ago. Over 100 years ago, an author who was watching this stuff said, "The present is a time of overwhelming interest. Rulers and statesmen are watching the relations that exist among the nations, and they observe the intensity that is taking hold of everything." And were that author alive today, I think where we are would blow their minds.
Wow. Todd, tell me something I don't know.
The headdress that the prisoner in Holt versus Payne wanted to wear, 19 states and Bureau of Prison allow people to wear that. Hard to argue that's a security issue when so many other prisons seem to make it work.
Wow. Well, gentlemen, thank you for being here with us today. Enjoyed our conversation and looking forward to doing it again soon. Thanks again for you being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.